Thanks to Skillshare for keeping LegalEagle in the air. Learn to think like a lawyer for free for 2 months by clicking the link in the description. Attorney General William Barr wrote a 4-page summary of the Mueller Report. Here are the 9 reasons I don't think it makes any sense. Hey LegalEagles, today we're talking about the Barr letter. This is not the Mueller Report, as a lot of people have reported. This is a summary of the Mueller Report as conveyed by the Attorney General. The Barr letter purports to summarize the findings of Special Counsel Robert Mueller and his investigation into the Trump campaign and potential ties to Russian interference with our election. When the Barr letter came out on Sunday, I, like many Americans, read it cover to cover. But there were a couple things that stuck out to me as an attorney that just didn't make any sense. So here are the 9 things that I don't think make any sense in the Barr letter. Number 1. Why does the Barr letter only cover 2 of the 3 facets of the Mueller report? You might recall that Robert Mueller was tasked with investigating 3 things: a criminal investigation into potential ties with Russia, a criminal investigation into potential obstruction of justice by the president, and number 3, a counterintelligence investigation into Russian interference with the American election. But the Barr letter only deals with 2 of the 3 facets of the Mueller report and doesn't actually deal with the counterintelligence portions of the Mueller investigation. Why is that information missing from Barr's letter? Barr could have easily provided a summary of the counterintelligence portion of the investigation, but for some reason he chose not to. Why is that information not there? And we also learned that Barr is going to make a separate summary that can only be given to the Gang of 8 instead of the full intelligence committees in the House and the Senate. So why is there information that can only be provided to the Gang of 8 when a summary, even a top-level summary, can't be provided in the letter that is released to Congress in general and to the American people? Number 2, what does Barr mean when he says that the Mueller report, quote, did not establish, end quote, a conspiracy with the Russians? What does it mean to not establish in this context? The Barr letter quotes a portion of the Mueller report stating that, quote, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. The problem is that this phrase can mean wildly different things. Does it mean that there was no evidence at all? Or does it mean that there is a boatload of evidence, but there is not quite enough to meet the standard of beyond a reasonable doubt that is necessary for a criminal prosecution? If a prosecutor says that an investigation did not establish something, it doesn't mean that that thing did not happen. It doesn't even mean that the prosecutor doesn't think it happened. It means that the investigation didn't produce enough information to prove beyond a reasonable doubt in front of a jury that that thing happened. So in this particular context, we don't know which of those potential outcomes there is. Is it that there is absolutely no evidence, or that there is evidence but not quite enough to meet the legal standard for a criminal prosecution? The difference between those 2 things is incredibly large and is very important as it regards what Congress is supposed to do next with this investigation. Number 3, why does Barr suggest that there can be no obstruction of justice when there isn't a conviction for an underlying crime? Attorney General Barr suggests in his letter that you cannot have a conviction of obstruction of justice when there is no underlying criminal act or a conviction for an underlying criminal act. But that's simply not the case. A conviction for an underlying criminal act is not necessary for a conviction of obstruction of justice. Just talk to Martha Stewart, Barry Bonds, Bill Clinton, or Kwame Kilpatrick. The last example is especially illustrative because former Detroit Mayor Kwame Kilpatrick went to jail for obstruction of justice in 2008 after he lied under oath about having an extramarital affair. Having an affair is not an illegal act, but it's often embarrassing, especially for politicians, and they can go to jail for obstructing justice to prevent that information from coming out. This is especially worrying because Barr wrote a now famous, perhaps infamous, 19-page memo laying out a very idiosyncratic view of obstruction of justice. In the 19-page memo, Barr opined that, quote, the president's motive in removing Comey and commenting on Flynn could not have been corrupt unless the president and his campaign were actually guilty of illegal collusion. The vast majority of legal scholars agree that this is simply not the case, that even in the absence of an actual guilty verdict of illegal collusion or conspiracy or coordination, that is not necessary as a predicate for obstructing justice into that investigation. But that brings me to point number 4. Why does Attorney General Barr think that there was no crime? Even taking Attorney General Barr's idiosyncratic view of obstruction of justice at face value, even so, there was crime that was found in the Mueller investigation and throughout the investigations into the president. President Trump is effectively an unindicted co-conspirator in a felony campaign finance violation with Michael Cohen. Hiding, or at least preventing the investigation into that embarrassing affair and illegal conduct is more than enough reason to obstruct justice and can give rise to the corrupt mental state necessary to be guilty of obstruction of justice. Potentially that investigation was farmed out to the Southern District of New York, but even still, that is potential criminal conduct that could give rise to obstruction of justice. Not to mention all of the other convictions of Papadopoulos, Manafort, and Flynn. So the question is, why would Barr or Mueller himself limit the crime at issue to the very narrow definition of Russian conspiracy that was talked about in the Barr letter? I don't think that makes any sense. Which takes me to point number 5. Why didn't Robert Mueller decide the obstruction issue? The Barr letter states that, quote, after making a thorough factual investigation into these matters, the special counsel considered whether to evaluate the conduct under department standards governing prosecution and declination decisions, but ultimately determined not to make a traditional prosecutorial judgment. The special counsel therefore did not draw a conclusion one way or the other as to whether the examined conduct constituted obstruction. That doesn't sound like Robert Mueller declined to prosecute because of the facts or that there wasn't enough evidence, but because of some countervailing legal issue, perhaps because of the DOJ policy not to indict the sitting president. But the Barr letter goes on to state that, instead, for each of the relevant actions investigated, the report sets out evidence on both sides of the question and leaves unresolved what the special counsel views as difficult decisions of law and fact concerning whether the president's actions and intent could be viewed as obstruction. To me, that doesn't make any sense. If the facts were 50-50, what we call equipoise in the law, that doesn't meet the standard of beyond a reasonable doubt. When there is some evidence, but not enough to reach the very high standard of beyond a reasonable doubt, then a prosecutor declines to prosecute. In fact, Mueller apparently did exactly this with the collusion, coordination, and conspiracy investigation, which Barr summarizes as finding that Mueller did not find enough evidence to establish those crimes. So why did Robert Mueller punt on the obstruction question, but not on the collusion and conspiracy question? Which brings me to the next point, point number 6. Why did William Barr weigh in on the obstruction issue? William Barr is a recent political appointee by President Trump. The point of the special counsel statute was for a neutral party to investigate the executive branch. If Robert Mueller found enough evidence to convict someone for obstruction of justice, the Barr letter appears to state that Robert Mueller did not decline to prosecute for obstruction of justice because there wasn't enough evidence, but because of some other legal issue. Then does that mean that Robert Mueller intended for William Barr to weigh in on the question? Or did Robert Mueller intend for Congress to answer this question? Was it intended to be teed up for Congress to make that decision? Declining to make a, quote, traditional prosecutorial decision is not necessarily inviting the political appointee, William Barr, to make that decision. And on top of that, Robert Mueller, as special counsel, has exclusive jurisdiction in this matter. Why did he decide not to move forward with the obstruction prosecution? We know that when Robert Mueller does not find enough evidence to prosecute, he makes a decision not to prosecute. But here, in the context of obstruction of justice, Robert Mueller is refusing to make any decision whatsoever. We will only know what that means when the full Mueller report is revealed. And on top of that, how is it possible that William Barr can make this decision in 48 hours when Robert Mueller couldn't make the decision in 2 years? And was William Barr even able to review all of the underlying evidence in this case? We don't even know how long the Mueller report itself actually is. Which brings me to point number 7. Whose legal conclusions are these, and are there other legal conclusions that we haven't seen yet? The Barr letter only purports to convey Mueller's top-line findings and does not include any of the underlying evidence or legal analysis that undergirds those findings. The Barr letter talks about the 2, quote, principal findings of the Mueller report, but does that mean that there are other legal findings that Mueller concluded that are not part of these top-line findings? And as to the legal conclusions that we have, we don't know whether Attorney General Barr concluded that the president did not obstruct justice as a factual matter, or that it wasn't legally possible for him to have obstructed justice. Again, going back to Barr's unsolicited 19-page memo, he argued a minority position that a president effectively cannot obstruct justice when it comes to using his Article 2 power. And Barr also argued that the obstruction of justice statutes don't apply to the president because they do not specifically mention the president. If Attorney General Barr imputed those minority legal positions onto Robert Mueller in the investigation, then it was effectively impossible as a logical matter for the president to have conducted obstruction of justice. Which brings me to point number 8. Why did Barr quote the portion of the Mueller report that states that the Mueller report does not exonerate the president? The Barr letter is potential partisan whitewashing. We don't know what's in the underlying report, and we don't know how accurate of a summary the Barr letter actually is. It's possible that Barr is intentionally setting the narrative before the full Mueller report comes out. But even still, why include this cherry-picked phrase that is actually detrimental to the president, stating that the Mueller report does not in fact exonerate the president? If a report or evidence doesn't exonerate someone from a crime and you're writing a summary about it, you don't have to include a sentence that says the report does not exonerate that person. You can just leave it at the fact that the crime was not established or that the decision was made not to prosecute. You don't have to go to the extra step and say that it doesn't exonerate that person. It seems like an odd inclusion in this very high-level summary of the Mueller report. Which takes me to point number 9, which may be the most baffling thing about the Barr letter and potentially the Mueller report itself, which is that there was a decision made not to prosecute for obstruction of justice, but that decision was made without interviewing the president. Was there an effort to actually interview the president? We know that under past precedent, under the Clinton versus Jones affair, and also the Starr investigation into President Clinton, that the president can be made to stand for an interview. Was an effort to get President Trump to stand for an interview made? And on top of that, why allow the president to offer written answers to written questions in lieu of an actual oral examination? Obstruction of justice requires proving that the defendant had a corrupt motive in conducting the acts that constitute the obstruction of justice. The best way to determine that is to interview the defendant. Now, potentially the defendant can take the Fifth Amendment, but here, given that the best evidence one way or the other is going to come from the president about his motivations in taking these different actions, why was the president not interviewed in this investigation? Now that the investigation is done, Attorney General Barr is going to have to read through thousands of pages of the Mueller report to determine what can be publicly released. He could really benefit from a speed reading class to get through the full Mueller report quickly, like Silvio Marisca's Skillshare class on speed reading, which could teach Barr to triple his reading speed in 7 days. Silvio's class could teach Barr how to read the Mueller report at 1,000 words per minute, and at the same time improve his reading comprehension and retention. At that rate, we might actually see the Mueller report before the next presidential election. Skillshare is an online learning community that has over 20,000 classes on everything like lifestyle, design, technology, business, you name it. The first 500 Legal Eagles will get 2 free months of Skillshare when you click on the link below. The free premium membership gives you unlimited access to must-know topics so you can improve your skills and learn new things. So click on the link, get 2 free months, and start learning to think like a lawyer today. It could even help you read the Mueller report and figure out why he refused to make the call on obstruction. Do you agree? Leave your objections in the comments, and check out my other real law reviews over here, where I will see you in court.